Good morning, everybody. Welcome to America TV. Hi, I'm Maya Trainer. I'm one of the guides here at America, and we welcome our audience joining us online. We truly hope that you are doing well and staying safe amidst this outbreak. Well, anyway, for those of you who are first-timers here, hi, welcome to America TV for the first time. America is the U.S. Embassy's American Center. Our mission is to provide a space for young generations of Indonesia to learn more about the United States. We have temporarily moved to a solely digital platform, so you can enjoy our program from the comfort of your own home and help fund the curve of COVID-19. Don't forget to leave your questions in the comment box below, and our panelists will answer them later in the seminar. And for our friends here who are joining us through Zoom, there are a couple of features that you can use to actively participate in the seminar. You can use the raise hand section to ask your questions with your video on, or you can also use the chat box section whenever you wanted to say hi to the other participant and also the panelist as well. But please keep in mind to use these features wisely. Alright? Cool. Now today we will be having a session titled Knowledge at America, People Participating in Policy Making. A friendly reminder for all of you, as continuation of our 10th anniversary celebration and Women's History Month in March, we are having a very special activities with giveaways this month. In this giveaway, we're giving out 10 tablets for 10 lucky people. So make sure to stay tuned till the end of this event to know how to participate. In the meantime, I will break the ice a little bit with our social media quiz. You guys ready? Okay, here we go. The question is, according to Pew Research Center, in the past 4 decades, the number of democratic countries has been A, decreasing, B, increasing, C, staying the same. I will repeat the question one more time. Listen carefully. According to Pew Research Center, in the past 4 decades, the number of democratic countries has been A, decreasing, B, increasing, or C, staying the same. You can participate this quiz through our social media comment section and stay tuned till the end of this event to find out if you get the answers right. And now, before we begin, here's an opening remarks from Bapak John Sayes, Political Officer, U.S. Embassy, Jakarta.
Selamat pagi and good morning. Nama saya John Sayes. Saya seorang diplomat dari Kedutaan Amerika Serikat. I work in the U.S. Embassy's political section. I'm excited to see such a diverse, eager, and engaged crowd interested in public policy. Together, we will have the opportunity to discuss the roles of citizen engagement in the policy formation process and how we can use various tools and opportunities to shape decisions within our political framework. The United States and America and Indonesia share many characteristics as countries with large, diverse populations and economies that expand across vast geographic spaces. Government representatives from our countries must consider the needs of many different groups with differing priorities when forming or implementing laws in our country. We, together as citizens of countries that share many values, live under democratic political systems with representative governments that encourage participation to influence, implement, and improve these policies at all levels. Citizen engagement is an essential component of a healthy democratic system. Through engagement, together we can identify and anticipate the challenges we need to address on various issues, including the safety of our communities, economic opportunities for our population, and sustainability for our resources. Our voices are necessary to ensure governments at the local, regional, or national level truly service the needs of our citizens. Our policymakers have difficult jobs. They must balance competing priorities, interests, and principles with each decision in hope of improving our societies. We will consider how citizen advocacy fits into this system to push for an outcome consistent with our goals and ensure the policymaker understands our needs, our morals, and our vision for the future. However, this is not without challenge. We must consider the best forums, tools, and opportunities for engagement. We must understand the obstacles we all face to ensure governments take into account our voices, priorities, and concerns, and that our formation and our foundations really contribute to a policy that maintains pace with the dynamic and evolving world around us. But we must ask a few questions. Most importantly, how will you all, the eager, educated, and active youth of today, become the professionals, entrepreneurs, and advocates of tomorrow involved in this process to improve our respective countries and, of course, the world? Whether we care about promoting economic development, environmental sustainability, the quality of education, access to healthcare, human rights, or democratic values, or more specifically, have an interest in strengthening ASEAN centrality, building the legal foundations of the digital economy, or even just encouraging more effective government. I am confident that each of you with an interest or cause that you care about can find a path for engagement with your community to shape policies and improve the world around you. To paraphrase an often quoted former US president, you can make a government of the people, by the people, truly work for the people. Now, you all aren't here to hear me talk. You are here today to learn from the true experts. Without further ado, I would like to thank America for organizing this opportunity for you all to engage with excellent American and Indonesian professors. Professor Mark Cammack from Southwestern Law School in Los Angeles, and Professor Bivitri Susanti from the Indonesian Jakarta School of Law in Jakarta. Terima kasih, saya berharap semua sehat, aman, dan siap untuk masa depan. Thank you.
Thank you so much, Bapak John Sayas, for the opening remarks. And now, without further ado, please welcome our moderator for today, Mbak Vulkania Neisa Almanadin, Associate at Umbra.
Everyone, it's a pleasure to meet all of you guys today, and I hope that we'll be having a fruitful session ahead.
Please take it away, Mbak Kania.
Thank you very much. So we have with us today two very insightful and prominent experts, both in terms of Indonesian law and US laws. It's an honor for all of us to have these two prominent individuals share with us their knowledge and expertise. And I invite all of the participants to listen, to perhaps, if you have any questions, perhaps note them down, share them on the chat box, so we can touch on them at the end of the session. I would firstly like to welcome Professor Mark McCammack. Professor Mark McCammack is a professor of law at Southwestern Law School, Los Angeles, and he has been teaching law and pursued his interest in comparative law and the Indonesian legal system. He has been teaching for some time, and he is currently with the faculty at Southwestern and was named as the Ireland Professor of Law in 2001. And we also have with us Professor Bivitri Susanti. She is a lecturer with the Indonesian Jakarta School of Law in Jakarta. And she is one of the pioneers of the founding of the Indonesian Center of Law and Policy Studies. Now, without further ado, I would like to give the floor to Professor Mark Cammack to share his presentation.
Hello, everyone. Selamat pagi, selamat siang, whatever it is there in Jakarta. I appreciate I'm hearing the feedback. Is that a problem with everybody else? I'll just go ahead and talk. I appreciate this invitation. I usually make a trip to Indonesia about once a year, but haven't been able to come this year because of the pandemic. So I appreciate the opportunity to be with you virtually for a while. And I'm especially pleased to share this virtual stage with Bivitri. I've known Bibi for a long time, I think almost 20 years now. And it's been a real pleasure to watch her realize her potential, the potential I saw 20 years ago and become such an important voice for law reform in Indonesia. When I first met her, she was barely out of school. And nowadays, when I open the paper, look on TV, she's debating the former Chief Justice of the Constitutional Court or moderating the debate among the presidential candidates. So congratulations, Bibi. Nice to see you. I'm going to share my screen here, hopefully. Is that working?
Yes, Prof.
Good. Okay, so the title of this session is People Participating in Policy Making. And I'm going to talk about two specific mechanisms or processes through which American citizens can participate directly in policy making. But before I do that, I want to talk a little bit about American political culture in general, and specifically about an aspect of the American national personality that is distinct, in my view, which is a general distrust of government. Every country has, to some extent, its own distinct personality, and this distrust of government is one of the features of American political culture that is particularly significant. So I'm not talking about distrust of any particular government. So we're not talking about the people's distrust of the Obama administration or the Trump administration or any other administration. What I'm referring to is a distrust of government in general. The Americans in general have an attitude that government very often does not do a good job of making their lives better and presents a more or less constant risk of making their lives worse. So this kind of broad generalization clearly doesn't apply to everyone. There are 350 million Americans, and those 350 million people have very diverse attitudes toward government and what government can do for us. I am personally among those who generally trust the ability of government to do good things. But I have cousins, for example, who are pretty convinced that government is more often a force for evil. This flag, which pretty much every American will have seen at some point, is a symbol of that sort of general attitude of distrust toward government. This snake that's coiled up and ready to strike is symbolized the necessity of protecting the people from, of all things, their government. And the flag was originally created during the American Revolution when Americans were fighting for independence against the British, and it was created as a symbol of anti-British or anti-colonial sentiment, but it's still used today. And today it's used as a symbol of opposition to our own government, the one that we have created and participants we have chosen, which I think shows how it is that Americans have this sort of distinctive notion that government can often be a problem. One of the most prominent members of the group of government skeptics, the group that believes that government is generally a bad thing, is Ronald Reagan, who was president of the United States in the 1980s. And during his first inaugural address, which is the speech that presidents give when they're sworn into office, President Reagan said, "Government is not the solution to our problem. government is the problem. And I say not everybody believes that, but it has that attitude, which is shared by enough of people that it affects the way that policy is made and the way that our government is structured, the way that policy is made, the way that citizens are given opportunities to influence the law and the public policy directly in order to bypass it. There are lots of examples of the way Americans are more distrustful of government than others. And one recent example is widespread opposition to government efforts to try to control the spread of the coronavirus. There are polls that show that large numbers of Americans, and it's not a majority, but a significant number of Americans don't believe information provided by the government about the virus because it comes from the government. There are also significant numbers of Americans who refuse or resist efforts, as they say, to try to control the spread of the virus, to wear masks, to close businesses, to restrict access to businesses. This photo here is a picture of a protest against those government restrictions. And as you can see, this one person is carrying a sign that says, "Government kills more than COVID." Another, perhaps the best example, or maybe the most extreme example, is what is referred to as the Second Amendment right to bear arms. And this is a provision in the United States Constitution that guarantees American citizens the right to own guns, which seems like a strange kind of right to include in a constitution. But the reason for putting that right in the Constitution was the same fear of government. It was believed at the time that it was necessary to permit ordinary citizens to own guns so that if the government became despotic or oppressive, the people would have the wherewithal, the means to rise up in revolt and replace or create a new government. And that view is a little bit hard to maintain in the 21st century when the kinds of guns that any ordinary citizen can have could hardly be very useful against the kind of weapons that the US military has. But this Second Amendment right to bear arms is still defended by some people on the grounds that Americans need to be able to replace their government if the government fails to serve its needs. This attitude of general distrust toward government goes way back in our history. Starts with the Europeans who colonized the eastern part of what is now the United States. These people were subject to British law, but were not given the same rights as other British citizens. And one thing they particularly objected to was the taxes that were imposed upon. One of the taxes, and this is just one of a number of taxes that became the focal point for resistance against British colonial rule and ultimately resulted in the revolution, was a tax on tea that was imported to the United States. So the British had colonies in South Asia, what's now India, colonies in America. They made their colonial, the people they colonized in India drove tea that they then turned around and sold to their colonies U.S. and made profit on both ends, including taxing the tea when it arrived in the U.S. And this particular tax, what became, as I say, a sort of focal point of opposition to British government in December of 1773, just 3 years before the United States declared its independence, or the American colonies declared independence. A group of what they refer to themselves as patriots, meaning those who were opposed to the British colonial government. They disguised themselves as American Indians, got onto one of the boats that was bringing tea from England and threw it all into the ocean. This is ironically referred to as the Boston Tea Party. As I say, it is an illustration of this view that the government was distant and unresponsive, and gave rise to the feeling that in order the government that was going to be created in the United States was going to replace the British had to have mechanisms in order to check government power and ensure citizen participation in lawmaking. So the American independence movement is somewhat different from independence movements in other parts of the world, because the Americans weren't revolting against a foreign government, a government that was deemed foreign. The people who lived in the American colonies considered themselves to be British. They were revolting against the government that they considered to be oppressive. And as I say, it was this concern about oppressive government that shaped the way the American Constitution was written, and also has had kind of long-lasting effect on American attitudes. So the colonies declared independence from England in 1776. George Washington, who was the head of the colonial army, or the anti-colonial army, led the War of Independence that finally ended in 1783 in the treaty that was signed in Paris. Then in 1789, the 13 colonies joined together under the Constitution of the United States of America. There were states before there was a United States, and it was the Constitution that created the government that made them a single country. And there were two principal ways that the Constitution sought to limit the power of government. The first was the principle of separation of powers, by dividing government authority between Congress that made the law, or the legislature that made the law, the executive branch headed by the president that enforced the law, and the judicial branch that interpreted the law. It was believed that that would help ensure that no single branch would be able to acquire the power that would make the government oppressive of the rights of the people. This notion of each branch of government checked the power of other branches, so the government as a whole remained relatively subject to this kind of restraint. And then the second was the fact that governmental power was divided between the central government, now in Washington, D.C., and the governments of 50 states. And the early Americans were concerned about the power of all government, but they were particularly concerned about the powers of central government on the grounds that it was more distant from the people that were being governed. And so the most significant powers were given to the states. The powers of the central government were relatively limited. They've grown over the course of the last 2 centuries, but most of the powers to make law remain with states. So it's the states that have charge of criminal law, all sorts of civil law, contracts, corporations, private wrongs, family law. It's only a relatively small number of matters that are under the direction of the central government. And so now all 50 states have their own government, each with its own legislature elected by the people, and each with its own judicial branch, headed by a Supreme Court, 50 different Supreme Courts in all 50 states, and then an entire court system underneath that state Supreme Court that interprets the laws. And each state also has its own executive, usually a governor. So one additional mechanism. So the government was structured in a way to try to divide and ensure that no branch of government acquired too much power, and people were of course given the right to participate in government through the right to vote. But another mechanism by which ordinary citizens were able to participate in interpreting and applying the law was the institution of trial by jury, which consists of a group of 12 ordinary people picked at random from the population who were called into court and then decide who should win in both civil and criminal cases. This right for ordinary citizens to participate in the decision of court cases was deemed so important that it was included as a guarantee in the Constitution. In fact, the right to trial by jury in criminal cases is stated twice in the Constitution. It was considered to be so important. And it's not immediately obvious, perhaps, how serving as a juror in an individual court case gives people, ordinary people, real power to affect public policy, but it does. In all cases, so the way it works is because jurors, of course, don't know what the law is. They're called into court. They sit over on one side of the courtroom, listen to the testimony, what the witnesses have to say, called by both sides. And when both parties have finished presenting their evidence, the judge needs to explain the law to the jury, which for the most part simply amounts to the judge reading to the jury the relevant statutes that govern this particular case. So if it's a criminal case, the judge will read those parts of the penal code that govern the crimes the defendant in the case is charged with, or in a torts case, read relevant provisions of the law that governs torts. So jurors learn what the law is from the judge, but then the jurors get to decide how to apply the law. And because the jurors don't have a professional understanding of what the law is, they have the ability of necessity many times to decide for themselves what it really means. And the jury's decision as to what the law means is pretty much final. Even if they misunderstand the law or apply the law in a way that a judge or a lawyer would consider to be incorrect, there's really nothing that can be done about it, because the jury deliberations are in secret and the jurors don't give reasons for their decision. They simply announce the result. And there are also cases in which jurors, the decision of an individual juror in an individual jury in an individual case can have a significant impact on public policy. One example, and we can talk about more examples later if you're interested, but one example is jury decisions in cases involving lawsuits against cigarette manufacturers. And over the course of the past several decades, juries have awarded enormous amounts of what we refer refer to as damages, money awards to plaintiffs who are suing the manufacturer of cigarettes, claiming that the manufacturer of cigarettes are marketing the cigarettes in a way that conceals the health effects. I can see I need to move along now. The other mechanism by which ordinary citizens are able to have an impact on public policy and law is what are referred to as citizen initiatives or voter initiatives. So through this is a process by which a group of citizens can get together, draft a statute, and if they can gather enough supporters through signatures on petitions, that statute is then placed on the ballot, voted on during an election, and if a majority of the voters approve it, it becomes the law. So one voter initiative that passed in California in 2016 made the use and possession of marijuana lawful. And this is a popular idea in a number of places around the United States. It has now also been made the law in Illinois and Massachusetts and Washington and a number of other states. But these voter initiatives don't necessarily relate to these matters that touch the lives of individual citizens in that type of way. They also include initiatives or propositions, as they're called, that deal with highly technical issues. This is a list of the voter initiatives that were on the ballot in California just last year. And one that received a lot of attention that I'll try to explain just briefly was a law that changed the status of workers who the rideshare drivers, what they're called here, but in Indonesia, you know them as Gokar or Gojek. And under California law, they were to be classified as employees, which gave them particular benefits. They had guaranteed minimum wage, they had insurance, health insurance, paid time off, unemployment insurance. But these companies that ran the rideshare companies, these big wealthy companies, didn't like the idea that they had to treat their drivers as employees, so they got together, wrote a proposition or a voter initiative that would make them independent contractors. And if they're independent contractors as opposed to employees, they don't have the same kind of rights. These big companies then poured millions of dollars into advertising in order to persuade Californians to vote in favor of this proposal to take rights away from rideshare drivers, and for reasons that we could talk about later if any of you are interested, a majority of Californians were persuaded, the initiative passed, and though all those rideshare drivers lost their benefits. So I'll leave it at that.
Thank you very much, Professor Cammack, for the insightful presentation. I personally always think that it's interesting from an Indonesian perspective to learn about how things work in the United States, how laws are made, and the history of lawmaking in the United States, because in some ways, Indonesia and the United States are very similar. We're both democracies. We both have a huge array of diverse ethnicities, beliefs, and it's always interesting to see what kind of differences, what kind of similarities are there, perhaps to take away some lessons from the United States for implementation. I would just like to summarize some of the interesting points that Cammack pointed out. Firstly, how in the United States there is an underlying seed of distrust of government. This can be seen in the Second Amendment, the rights to arms, with respect to colonial Americans, going on having being subject to taxation without being represented, and this evolved to somewhat pushing for public involvement in governance and in lawmaking. And public involvement in the United States is evident in several ways. Aside from voting, citizens can also serve as jurors. There are also citizen initiatives to propose new laws and law amendments. But Professor Cammack also highlighted that there are possibilities that for businesses to sponsor voter initiatives to vote in a particular way. So this is something I think which we can explore further in our discussion session. Again, thank you very much, Professor Cammack. Now I will have to open the floor to Professor Bivitri Susanti to present her materials. Professor Susanti, the time and place is yours.
Okay, thank you, Kania. I hope everything is okay with the connection because I can hear there's an echo. Anyway, I hope everyone is in good health. I would like to use the opportunity to discuss with Mark and all participants to reflect on the Indonesian context of public participation in law and policy making processes. And there are three sections of my presentation. First, I would like to provide or to discuss legal framework and its challenges, legal framework for people's participation in policy making and its challenges. And the second part will be on the role of the court in terms of the policy making. And the third part is looking at the future, how we are going to deal with it with the experience shared by Mark Cammack. So let me now share my short presentation. Okay. So let me start with the first part of the discussion, which is the legal framework of the policy-making processes and its challenges. I'm sure because I have had all the list of participants and also the chat from these various universities in Jakarta, especially. So I'm very happy to have you here, all of you as participants. And I'm sure all of you have understood that we do have this so-called hierarchy of laws and regulations. But let me just briefly talk about this so we have, common ground to further discuss this topic. We know that when we talk about why I always say law and policy, because in the Indonesian context we have law, undang-undang, and or government regulation in lieu of law or perpu, peraturan pemerintah pengganti undang-undang, and then we also have regulations under the law, which consists of government regulations and then president's regulation and then local regulations. But thirdly, we also have other regulations made by institutions attributed to make regulations. For example, the House of Representatives, the Anti-Corruption Commission, and many other institutions. And they are all based on Article 8 of Law number 12, 2012. Law number 12 of 2011, is the key legal framework for us to talk about law generally, especially lawmaking process. And then we also have the fourth one is, let's just loosely call it policies. And what I mean by policies is the administrative law decision or keputusan tata usaha negara, or usually in law faculties or law schools in Indonesia, we call it beshiking, basically it's administrative law decision. So looking at those laws and regulations, then we can see the legal framework for participation. First of all, we know that the law number 12, 2011, regulating public participation in law and regulation making processes. And then there's also general principles of good governance. I will talk about them later on. but let me just first pose the problems. First problem, which public? What are stakeholders? Are they scholars like me and Mark, or NGOs, or societal groups impacted by the policy? Yeah, people who are directly will get the impact of the policy or laws. That's the first problem. And secondly, what happens to the law or policy in question when there was no participation? Because courts have not decided to nullify any of this kind of laws and regulations. And I'm both happy and sad to share my experience just last week. Actually, this helped a lot for me to create this presentation and think about what I'm going to talk about in this session, because I was in the court just last week, on Thursday, if I'm not mistaken. It's the Pengadilan Tata Usaha Negara Jakarta, Jakarta State Administrative Court. And it was, the topic was the decision of the government to continue with the local election during the pandemic. And at that time, I was there in my capacity as saksi ahli, expert witness in the court. And what is interesting is there was a debate between us. I mean, I'm with the petitioner against the government, between us and the government representatives when we talk about public participation exactly. So when I share my opinion to the judges, to the court, that public have to be, heard and considered, and also expert, because we are talking about the pandemic. So, Indonesian doctor associations have to be heard, epidemiologists have to be heard, and all that. The government representatives posed a question to me asking, so what is actually, groups in the public that we have to invite? So I explained theoretically and conceptually, but then the question went to what law, do we have to follow to determine which groups we have to listen to? So they need the actual articles, listing down, the characteristics of groups that they have to listen to. And then in the end, the government representative asked me again, so in the end, at the end of the day, it's us, the government, who has to decide, right? And I said, of course, because it's the policy. But that's why we have this court, because we can question you whether you actually listen to the public or not. So, I knew this fact, but to have that debated in the court, that, made me reflect quite a lot this past week. So, because apparently, if we talk about the legal framework itself, we have Article 96. I just copied, the Indonesian version of the law. It's the Article 96 saying that the Mark's Bahasa Indonesia is very good, I know. So I think Mark doesn't mind with this display in Bahasa Indonesia. The Article 96 says that the public has the right to provide input in the lawmaking process. And then Section 3 of the article says that the public meant in Section 1 are individuals or groups of individuals who have interest in the substance of the bill. So basically, how do you call it, stakeholders. And then Section 4 says that to make it easy for the public to provide input, then the bills have to be easily accessed by the public. So this sounds good, right? But what we later on know from the facts in the court, the government even says that without further qualification, this is how legalistic the view is, without further qualification on who exactly the groups of public or society are, then we don't have any legal framework to technically conduct this duty. And then we also know there's general principles of good governance. Let's call it that way. It's azas umum pemerintahan yang baik. It's developed from laws, especially law on government administration and law on state administrative court. But also, Mark will be very interested in this, I think. There is also a publication to develop this further based on court decisions and, of course, doctrine. So general principles of good governance include public interest, and further development in court includes accountability, rule of law, professionalism, and justice principles, prinsip keadilan. But then again, these have not been, used in reality in the law and policy making processes. And at this point, I should talk about the political system, because when Mark mentioned the distrust of government in the U.S., it came to my mind that there is also growing distrust of government from the Indonesian society at this point, but only from, I would say, the middle class, if we may call it that way. Many are not interested to discuss this issue, but many found that there are some problems in the current administration that made people, start to have distrust on the government. And so when we talk about political system, then I would discuss actually with all of the participants and Mark that there is a big problem that Indonesian political system does not encourage communication between the people and their representatives. I don't know if this is true in other parts of the world, but I think the situation in Indonesia is quite bad because it's really created by the system. So oligarchs, as informal political actors, have stronger influence on laws and policies. I mentioned this in particular because we have been having discussion on this oligarchy. And then to make it even worse, the current administration seems to view opposing opinions as distraction to harmonious political landscape. I was trying to find, the right translation for this, but really, harmony and gotong royong are the key words nowadays, as if good democracy is the one that is so harmonious, and protests are seen as distraction to the otherwise peaceful democracy, which in my opinion, when democracy is too peaceful, is not democracy anymore, because democracy also means that protests are encouraged and considered by the government. So, and then civil society protests on lawmaking processes are fought with violence, and activists are oppressed. So with that note, now I would like to remind you about the index, the democracy index by the Economic Intelligence Unit, which put Indonesia in the 64th rank of 167. And you can see the color here the color here, light blue, yeah, only 6.3. And let us just point out the angka merah, ya, in Indonesian rapot. This is called angka merah because this is under 5, under 6. And then let me go to the second part, which is the role of the court. There is judicial review on the lawmaking process, both by the Constitutional Court for laws and the Supreme Court for regulations under law. But the courts have not made any decisions on that. Constitutional Court, for example, ruled in 2009 that the Supreme Court law was flawed procedurally, but constitutional nevertheless, due to the usefulness principle, asas kemanfaatan. And then let me mention one more case, which was again in the state administrative law court. I mean, not law. A little bit typo here. There was a petition to challenge presidential letter accompanying the job creation bill due to lack of participation. It was dismissed by the state administrative court on the ground of court competence. I was there also as the expert witness at that time, and it was very interesting debate with the judges, but unfortunately, and the judges actually seem to understand the whole argument, but the political situation, I would say, made it much more challenging for the judges to decide, to accept that the petition. So the last part of my presentation is the reflection. I believe U.S. system is very beneficial to widen our horizon and stimulate imagination on how to reform. Because I remember in 1998 when we started the reform process, I had discussion at that time from the late Professor Daniel Lev, who talked about the need to have imagination to do the reform. And indeed, we learned a lot from many other countries, but those cannot be copied verbatim because of the differences on legal system, federal system, and other contexts. But it's really, I hope the discussion this morning will stimulate further thoughts from all of the participants. But I would like to note that there is urgent need to change general election and political party laws to develop relationship between elected officials and their constituents. And then we need to push changes on the repression of civil society movements. And we have to continue, despite the loss, continue using court as forum to change government action while maintaining court reform programs. So I will give back the forum to Kania. This is the end of my presentation. Thank you, and looking forward for the discussion.
Thank you very much, Professor Susanti. It was a very insightful session. It was very enjoyable for myself, and I'm sure for all of us. Professor Susanti explained earlier on how the legal framework under Indonesian law, setting out the various sources of law under Law No. 12 of 2011, and also explain on the legal framework for participation, for public participation, and raise very interesting and on-point questions. When we talk about public participation, who is this general public that we're referring to? And Professor Susanti also mentions that in Indonesia currently there's great need to improve the communication and involvement of public speaking with respect to the general public, citing that there is a general trend of emphasizing the need for harmony or gotong royong in the Indonesian language, but also which also discourages the hearing of dissenting opinion, which is still greatly needed. And Professor Susanti also outlined several areas for development, including in continuing to having a forum for the opinions, for public opinion, and to strengthen our court systems for the purpose of assessing the Indonesian regulations that have been there. Again, thank you very much. Now we move on to the next segment of our session, which is the discussion session. But before I do so, I would like to again remind the participants that we will be having a Q&A session, and this is perhaps a very rare opportunity that we have both Cammack and Professor Susanti, who are all who are experts on this field. So please have your questions in the chat box. If you would like to present them in Bahasa, that's also possible. Please don't be shy. So Professor Cammack and Susanti, perhaps to stimulate as a jumping point for the discussion now, I would like to start off by talking about when we listen to the public, when we involve the public, who do we need to listen to? In the sense that, is there a concern that the general public may not be necessarily knowledgeable or informed enough to make a decision that would impact the entire country? I understand that Mr. Kamek touched upon the voter initiative sponsored by Uber. I think it's Proposition 22, if I'm not mistaken. And also, Professor Susanti also touched on this in emphasizing which public are we listening to. So how do we ensure that if we involve the public more in policy making, that they would not be swayed by lobbyists, that would not be swayed by business actors, because it's still very much a huge concern when it comes to the elected representatives. Thank you.
I can speak to that briefly, I guess. I think, Kanye, you hit it right on the head. There is, if I had provided a list of things that urgently needed to be done in order to make democracy in the United States more effective, one of them would have been campaign finance reform, meaning changing the rules governing how candidates for elective office raise money. Because currently there are relatively few restrictions, especially when it comes to contributions by corporations, by companies. Elected officials rely on campaign contributions to get themselves reelected. And there's nothing that matters more to a politician than getting reelected. So politicians become dependent on those people who contribute to their reelection. And to keep those people happy, they vote the way that their campaign contributors want them to. They say the problem has become even worse in recent years because of a decision by the US Supreme Court that held limitations on contributions by corporations are unconstitutional because making campaign contributions is a form of speech. And under the Constitution, limitations on speech are not permissible, especially when it comes to political speech. So there's an argument to be made that the much of the political system has been captured by what are referred to as special interests that have the funding access to push their agendas, and that creates a really significant problem with doing things that benefit the public in general, or even doing things that a majority of the population supports. For example, there's been polling for decades that shows that the majority of Americans would favor stricter controls on sale of guns, especially military-style guns. But one of the most powerful lobbies in the U.S. is what's an organization of gun owners called the National Rifle Association that has prevented virtually any type of gun control legislation pass, at least on a national level. So, and as you pointed out, the point that was not really developed, what I meant to make, in this voter initiative initiative that was backed by the owners of the rideshare companies was presented to the public in a very deceptive way. And they were able to do that because they had 20 times more funding than did the opponents of the legislation. It's a complicated issue what the rights of a employee are as compared to the rights of an independent contractor. And the rideshare company had put provisions in the law that gave some benefits to their drivers, but not nearly the kind of benefits that they would get if they were employees. And they could point to these things and argue that their drivers were really better off with if they were independent contractors, which in fact they weren't. So the ability of the well-funded elements in society to shape the way the issues are discussed and to simply buy essentially the votes of the people's representatives through the campaign finance issues is an enormous problem.
Thank you, Professor Cammack. Perhaps Professor Susanti, would you like to add?
Yes. First of all, I agree with Mark about the campaign funding and also political party funding. So there are problems in that regard, as well as I mentioned before, the need to actually build the system where, for example, the political party would have cadres, and not only vote getters who will go to House of Representatives building, who understands more and who knows actually the people whom they represent. But I use that last part of Mark's response to respond to Kanya's question. So which, if we talk about which public do we have to invite or involve, then the question is always normative and doctrinal. By that, I would like to say, well, frankly, the past weeks, I have been thinking about, do we actually have to have further regulation on that to qualify which ones are appointed? But there's still a big question mark there. Why? Because first, that would make the lawmaking process, which is in principle is a political process, will be very technical. And in the end, it might lead to probably some groups are not taken into account because it doesn't match the qualification, and probably the representatives or the House members will only use that as a checklist, as how they usually treat that. Because we very often, even for us as scholars, we are very often invited just to justify the process. Say that there is, they call it uji sahih or socialization. This is an interesting word for me, Mark. There's no translation actually for socialisasi, but that's the term that they use to say that there has been a kind of public participation process, but actually it's a top-down process where they would just present with PowerPoint probably, and then there's no question and answer. So that's one problem. And so how do we have to do that? I think actually the court should have role in this. It should be tested by the court, because as principle there has to be a public participation, because if we learn about policy making or policy generally, because I also teach one or two sessions in public policy class in my law school, and always we have to learn that public participation is a must. It's the principle, the main principle. But if it's not done, then it has to be tested by the court. But then again, the court has not done so. So currently, we have at least two laws in line. The first is the revision of the KTK law, and the second one is the job creation law. Both are in review formally. We call it a formal judicial review. And experts like Professor Jimli Ashidiki and many other experts, Professor Susi Dwi Haryanti and all that, they all have been encouraging the court to finally make decision on this. But it hasn't done so. So we are lacking kind of guidance legally that will force the decision makers to have public participation in the policy making process. Thank you, Kanya.
Thank you very much, Professor Susanti. So I think that perhaps the main two leads in as to how we can help improve the rate of public participation is to focus on controlling, or not really controlling per se, but more of having a greater transparency on campaign funding, communication on the regulations and how the public can participate, including by way of utilizing the court system. And I would just like to jump off of the point mentioned by Professor Susanti on how the current system, at least in Indonesia, when it comes to lawmaking, is very top-down. And I completely agree with that assessment. I would like to jump from that point into perhaps asking your opinion if you have any ways in mind to improve communication on the process of lawmaking, the progress of regulations to the public. Why I'm asking this is because this is in light of the recent omnibus law in Indonesia, or the job creation law in Indonesia, where there were several criticisms lodged against the government, saying that the process was not transparent enough. And I think one of the points raised was that the public wasn't really provided with a draft, the latest draft of the law to assess. And I think up until the promulgation date, and even a couple of weeks thereafter, there was still confusion as to which is the actual draft that has been passed. So at least in Indonesia, it can be very, very difficult for the public to be involved in the process and to be aware of the specific content of the regulations that are being discussed. Perhaps do you have any specific recommendations on what the government can do to improve this?
Thank you, Kania. I would say, first of all, to allow greater access to the information, first of all, the government has to have longer time for discussion. Because I think what the main problem of job creation law is the fact that it was discussed in a very short time. And they always say 9 months is long. Yes, but we are talking about thousands of provisions. So it's not long enough. That's one, yeah, about the time to conduct the participation and access of information, open access to information and all that. And secondly, I would say that the government actually has to develop some kind of, this is very technical, but I think this will always be useful, to develop kind of database of stakeholders. So it will be easier for them to identify whom to invite, who will get the impact of the law, and all those things. And the third suggestion will be on the use of technology. I think we haven't that enough in terms of getting input from society. So I think those three, at least that's what I can think quickly for now.
Thank you. Professor Cammack, perhaps would you like to add any suggestions?
Just briefly, and now entering an area that's well outside my area of expertise, but particularly with respect to administrative regulations. As in Indonesia, a good part of lawmaking in the US actually happens in the executive branch, when Congress will authorize an executive branch agency, the Department of Labor or the Department of Health and Human Services, to issue regulations governing matters. And then they make laws that have a big impact on people's lives. But there's a process under what's called the Administrative Procedures Act that requires that before a regulation can be promulgated, there must be a period in which it's got to be published, made known to people who have an interest in this particular topic, and then there's a comment period. The agency has to then consider those comments, and only after this comment period extended are they permitted to issue the regulation. So it's a matter of inviting comments from people who, there's a process to make it public, and make public at least with respect to those people who have an interest in the issue, and then inviting them to make comments. And again, this is not something that I have any real expertise in, but there is a well-developed system for public comment when it comes to at least federal regulations. I don't know how far, I don't know anything at all about the regulation making at state level. I'm sure there's similar kinds of processes, but not as well developed, I'm guessing.
Thank you, Professor Cammack. Perhaps one thing that I also find interesting when I speak with my colleagues who are in the U.S. is that there's a greater culture of citizens calling their elected representatives or sending emails, filing petitions, and at least there's a more clear and informal line of communication. I find as an Indonesian and some of my other peers also find that sometimes it can be quite difficult to reach out to have our voices heard, unless if you are part of if you're a legal expert that's so happen to be invited by the House of Representatives. And I completely agree with all the points about having more time, utilizing technology to disseminate information. I believe that the DPR on their website also has a category of regulations that are currently discussing. I just hope that in the future they will be utilizing this more, because I think as of now, it's quite underutilized. I would also like to jump off of a point mentioned by a professor that how important the role of the executive is in lawmaking. Because I think when we talk about the executive, in Indonesia at least, we deal with a lot of decisions with informal policy. And Professor Susanti mentioned this in the context of administrative decisions, beshiking. But I'm wondering, where do unwritten policies stand in U.S. and in the Indonesian legal hierarchy? Because I personally, as a lawyer, I see this a lot. So a lot of my clients myself have encountered policies that are not written, but are nonetheless enforced by government agencies. And sometimes it can be a question of legal certainty for the general public, because these are not policies that they can necessarily be well aware of unless they're really in the industry. But I also, on the other hand, understand that not everything can be referred to laws. Given the industry, given the rate of development, there is need to have these policies in non-writing form. So if I can have your insight on that, that would be great.
That is a really interesting question, but my experience just doesn't give me any basis for saying much about it. I am confident that there are matters that are regulated by a sort of a custom that is never actually written down, but I don't know how I don't know the extent to which that occurs, if there's any mechanism to try to control it, but it's a very, very interesting question that somebody ought to look into if they haven't already in the U.S.
Thank you, Professor Cammack. Professor Susanti, you'd like to
Yeah.
add?
Yeah, I think we in the Indonesian context, we can talk about two things. First is what we call discretion in the how do you translate it? Undang-Undang Administrasi Pemerintahan, Government Administrative Law, that is law number 30 of 2014. And also there is, in the same law, it mentions that things that are verbally provided by public officials can be seen as policy. So there is this term called fictive positive. Yeah. For example, if there is some a permit that has not been issued, for example. But another example, a good example, is the recent decision, again from the State Administrative Court, on the policy. It was not really written, yeah. It's the policy to cut the internet in Papua. So the court decided that action of the government is against the law, perbuatan melawan hukum oleh penguasa, ya. I don't know. I think it should be similar to tort, but by the government. So this is also an interesting development. But Kania, you're right that there is a big question on legal certainty. So when I discussed it with colleagues and students, I usually remind them that as lawyers, we should demand that those policies are written. But then again, if there is no written policy, then in terms of legal framework, we can use the government administration law. Thank you.
Thank you very much, Professor Susanti, for the insight. I think now we should move on to the question and answer session. I would like to invite Muhammad Haikal from Venus University. I think you had a question. Would you like to turn on your video to ask the question directly? Yes.
Okay, so my question was, you said something about regulating donations and raising money for politicians, right? But in the case of when politicians use their own money, how are they expected to uphold democratic values and not preserve their own self-interest when they spend a lot of money to be in their own position? So that's my question.
Thank you, Muhammad Haikal. Perhaps Professor Cammack, would you like to address this question first?
Yeah, it's a very interesting question. And the answer is basically, if somebody is capable of funding their own campaign, then they have the ability to fund it to the extent of their wealth, and there are really no restrictions on that. It doesn't often happen that people who have a lot of money are willing to sink all that money into a political campaign. It does happen. It happens occasionally, but is not as common as you might think. President Trump certainly wasn't willing to put his money into his campaign. He raised the money in the same way other politicians do. There are examples of, as they say, people who've self-funded their campaigns, and that gives them freedom. And people who do that often tout that very fact. They say, I'm not dependent on those people who provide political contributions the way other politicians are, and therefore I can act more independently. But it's a relatively rare occurrence.
I think I can just jump in.
Yes,
Thank you,
please.
Haikal. This is very, very interesting question. It's really important. I would like just to add to Mark's comment. I would just add two things. First of all, in the Indonesian context, it's about time to really review the campaign method, for example, because as I'm sure we all realize it, that our campaign method is still based on crowd, mass campaigning. So usually there's dangdutan, and all that, which was also very bad in the pandemic in last December, for example. And that requires a lot of money. That's one thing. So instead of, I remember, Mark, when I was in Seattle, some people actually came directly to, I was in Dan Lab's house at that time, to explain their program if they're elected, for example. Something like that rarely happens in the Indonesian context. We always use very expensive way of mass gathering for campaigning. That's one thing. And secondly, I think curbing the corruption during the election would also be the way to prevent that. What I mean is not only campaign funding and political party funding, but also, there's this serangan fajar kind of method where usually candidates will give envelopes with money in the morning of the election, or to provide us with T-shirts or jilbab, and you mentioned it, paraphernalia for the voters. That also requires a lot of money. So I think if we evaluate that and change the election system towards more, explanation of the program, what to do after the election and all that, that will be very helpful in making the representatives more accountable. Thank you, Kania.
Thank you very much, Professor Cammack and Professor Susanti, for the insightful response. I also believe that there's a question from Muhammad Akbar Araihan. Would you like to also turn on your video to ask the question directly? Can you kindly? I can, if it's not possible for you to speak directly right now, that's okay. Let me just help you ask the question. Feel free to jump in. So Professor Cammack and Professor Susanti, the question is basically on the concern that from in Indonesian perspective, in administrative laws, if a policy doesn't involve public participation, it can be deemed formally defective or can be canceled by competent authorities, as Professor Susanti also mentioned earlier. But I think Muhammad Akbar is the concern that there's no legal or political institution that really cares about public participation. He cited the issue in the preparation of the omnibus law on job creation. And in addition, he raised the concern that not all provinces and districts in Indonesia make special regional regulations on public participation as mandated by law. And he would like your opinion on this. And just to add a little bit for perhaps non-law viewers, so under Indonesian law, there are general regulations applicable on a national levels, but also there are also regional regulations that apply on a city, regency, and provincial level. So perhaps Professor Susanti, would you like to start?
Yes, I agree with Muhammad Akbar that it should be tested. And if the question is who should test that, I would say it's the task of the court. I mean, political system is one thing, and we can always protest, and we can always claim or ask to be invited and all that. But on the other hand, the check should be done by the court. And this is really a homework for our legal system. Because as I said before, the job creation law is actually something together actually with the revision of the KPK law of 2019 are two issues that have made legal experts like Jimli Ashidiki and other former Supreme Constitutional Court justices spoke out about this, about the need for the court to actually use their authority to declare unconstitutional laws that are not made, according to the public participation and other rules in terms of lawmaking process. So that's my answer. Thank you, Kanya.
The way it works in the U.S. is that someone who has an interest in having a regulation declared invalid can simply sue. And we don't have administrative courts. We do have administrative courts, but they're not like administrative courts in Indonesia. We don't have a special set of courts that deal exclusively with challenges to government conduct. That's just done in ordinary courts. But a person who objects to a regulation can file suit to have the regulation declared invalid on the grounds that the formulation didn't comply with requirements of the law. One high-profile example of that happening was the action by the Trump administration that sought to abolish the status of what are referred to as dreamers. These are young people who came to America with their parents, and they entered the country illegally, but they weren't responsible for, they were children when they arrived, and the Obama administration issued a regulation that prevented them. It simply established a policy that they weren't going to be repatriated back to their country. The Trump administration attempted to change that policy, but they simply didn't, as we say, cross all the T's and dot all the I's. They didn't follow the formal requirements of making a change in the policy. That was challenged. It eventually made it to the Supreme Court, and the Supreme Court said, no, they didn't adhere to the requirements of this administrative lawmaking, and therefore the regulation that the administration sought to implement was invalid. So, as in many things in America, it's challenged in a private lawsuit by somebody who's impacted by the law in the ordinary courts that have general jurisdiction over civil and criminal matters.
Thank you, Professor Susanti and Professor Cammack, for the answer. I hope that's clear, Muhammad Akbar. We also have Hoiro Islamia, who is joining us from Facebook. And the question that they have is, how can I be a good active citizen to support the government policy as a student? So this is a very interesting question. Thank you for this. Perhaps Professor Cammack, would you like to go first?
First of all, to be informed is that is often a problem in this country, that people, the general public, simply doesn't pay enough attention to a lot of issues to be able to have the kind of opinion about the issues that would actually enable them to act in their interest. So staying informed about the issues. One piece of advice that is given to Americans is simply to vote, because so many Americans don't vote. And by not voting, you're passing up on your opportunity to have an impact. There are also all sorts of ways that ordinary people can get involved. So if, for example, in a political campaign, if there's somebody who you believe is promoting policies that you're in favor of, you can join that campaign as a volunteer and go door to door handing out pamphlets, for one thing. Getting involved in NGO activities as a volunteer. There are lots of different ways you can do it, but those are a few illustrations.
Thank you, Professor. Professor Susanti, would you like to add?
Yeah, I would like to respond to the last part of Mark's response about involving in the political activities. I think I found that really interesting in the U.S. context, because I was also quite I would say quite amazed with what comparing Indonesian context and the U.S. context when I was in the U.S. when I saw that volunteers. I was there just before Obama was elected for the first time, so a long time ago. There were young people who volunteers in the campaign for Obama, and I found that really interesting. But then when I thought about my own country, I was thinking, so which party would I support? I don't find any, frankly. I mean, I think this is what it struck me, and it made me think about how distant Indonesian public with our political parties. I agree with Mark that it will be a good way to contribute if we, have a political party or person whom we trust. To some extent, it happened actually during the Ahok campaign, because he got a lot of support. Ada teman Ahok at that time, and it worked just like Obama campaign. But then again, if we talk about political party, then there will be a big challenge. And this also brought me to Kamia's point previously about how distant we are to our representatives, that we don't really send emails to our representatives like I can see my colleagues and friends in the US often do, and they will get, and it's really distant. So I think students can participate by, first of all, in terms of substance. Students can gather in their unions, BEM or other types of organizations, to actually provide input, because I read some written input from BEM Indonesia and all that given to the House, and that we don't know if they will consider it or not, but that's an effort that is really needed. And also to actually make noise in the social media, at least, or even in some peaceful protests, to voice what the students think best for the country. Over to you.
Thank you very much. Yeah, thank you very much, Professor. Thank you for the great suggestions. I think that these are all things that we can all do. If you're a student, if you're a legal practitioner, if you're otherwise working, you can all stand to be more active, do more volunteer work, be more active on social media. So I hope that all of these suggestions can be food for thought and fodder for future action for everyone who is currently watching. Now, I think I have two sets of questions from Abi Juana, who's joining us from YouTube. Perhaps I will read out the first question that is addressed to Professor Cammack, which is, what is the difference between legal comparative technique and comparative science itself? And how is it used, or how does it contribute to communities in Indonesia? I think because it's also relevant for in the Indonesian context, Professor Susanti, at the end, feel free to jump in. Professor Cammack, would you like to start?
I want to make sure I understand the question. It's about the study of comparative law. Is that the question?
Yes. What's the difference between legal comparative technique and comparative science? And how are they used?
We don't use those terms. And so I describe myself as a scholar of comparative law, but there isn't really any systematic agreed upon way of comparing different legal systems. There are various categorizing methods that have been used, but there isn't, from the American perspective, there is not a sort of a scientific or other social scientific method for systematically studying or comparing the differences between legal systems. It's a sort of an ad hoc approach, which is kind of typical of legal scholars in the U.S. in general. We don't consider ourselves, outside of sort of doctrinal analysis, which simply means understanding and critiquing the legal doctrine. And they're also scholars who work within another discipline, so who work within sociology or study law from a historical perspective or study law from an economic perspective to see the extent to which it produces efficient outcomes. But for comparative law, there isn't really any disciplinary methodology by which it's done. As some comparativists call on or use theoretical ideas drawn from other disciplines, like, for example, literary studies, but there really isn't that kind of discipline that is followed. Maybe Bibi can, since she knows.
Thank you, Professor. Professor Susanti, would you like to add?
Just briefly, I think Mark has outlined what I also understand as comparative law. I just add to the Indonesian context that I think from my experience with my own students, I often saw that students just comparing two legal systems as they are. I mean, without looking at the context of different countries. For example, the US and Indonesia, when Mark talked about the jury system, it's really intriguing. But then when we talk about it in the Indonesian legal system, there's no way to do it. Yeah, because we have very different histories and very different legal systems, common law and civil law. And then when Mark, and I'm so excited about the idea of having that some kind of plebiscite referendum on a number of issues such as the legalization of marijuana and other issues in California that Mark talked about. And I also experienced when I was in Seattle. It's really exciting. But when we talk about it in the Indonesian context, to have that kind of a referendum, then we will have different, very big challenges, because again we have different contexts, we have different political culture, we have different how they call it, rule of the game and all that. So I don't know exactly how to compare those two, but my message would be just not to transplant the idea like, oh, in the US system there's a very good tax system, for example, and then we just copy it to our system. That's not comparative law. So that's just my addition to it. Thank you, Tanya.
Yeah, thank you very much. So thank you, professors, for emphasizing the need to not only using comparative law as a tool, to not use it as is, and to really tailor your findings to the specific regional socioeconomic context where you want to apply it in. I would like to move on to the second part of the question from Abijuna, which is this time addressed to Professor Susanti, being the pioneer and founder of the Indonesian Center for Law and Policy Studies. The question is, if I may say this in English, is what do you think about the development of regulations and the national legislation priority list? In general, is it still relevant, or is it accurate to the function and the purpose of law and for social purposes for the last 5 years? Thank you.
Thank you. I think this is a very good question, Abijuna, on point. I just talked about this as well with my colleagues. I would say that, well, there is a study from PSHK and Mission Center for Law and Policy Studies about regulatory reform in Indonesia. The study was conducted 2 years ago, but it's still relevant because nothing has been done after the very thorough recommendation came up. Although PSHK did that study together with Bappenas, and also there were seminars all over Indonesia to talk about the recommendation. So one of the recommendation is to actually make the national legislative priorities in line with the national development plan. Even that basic idea, not simple, but basic idea that there should be some kind of connection between the planning, development planning, and the laws to be made by the House and the government are not yet done. So if we see the priority list just enacted yesterday, again, we still see the disconnection between the two. So if the question is then whether it's actually in line with the needs of the society, I would say actually not. And in addition to that, there's also the fact that at least the past 2 years, the government actually introduced laws that are not in the list of priorities. For example, the revision of the KPK law in 2019. The omnibus law was there in the list, but it was a little bit pushed into the list in the last minute. So I think the intention is not really looking at the need in the development plan, but more to cater the need of the political actors in the House of Representatives. Thank you.
Thank you very much, Professor. I also now have a question from Willie Yapin. Willie, if you are on the line, would you like to present your question directly by unmuting and sharing your video? Are you on the line, Willie?
Hello?
Oh, yes.
Okay. Yeah, in the disciplines of law, the government implements policy. Hello, can you hear me?
Yes, we can.
Okay, I'm sorry. In the discipline of law, the government implements policies through instruments such as wrangling, basking, as you said at the beginning of the discussion. However, the fact is that the government in issuing policies often blunders, and I want to ask your opinion, why the government tends to use legal discretion as an instrument in implementing controversial policies, for example, such as omnibus law and handling the COVID pandemic. Thank you.
Thank you, Willie Yapin. So the question is, you're asking the opinion of Professor Susanti and Professor Cammack as to why the government sometimes abuses perhaps legal discretion in implementing controversial policies. Professor Susanti, perhaps would you like to start with this?
Yeah, I think The answer would be, well, for practicality purposes, because if we talk about lawmaking process and also policy making process in general, then again the government has to have proper process actually. Although we have discussed before, there are still big question mark on that. And I'm actually interested in what Mark has mentioned about Administrative Procedure Act in the US. We should learn about that later on. But in Indonesia, we don't have that yet. But still, at least in the lawmaking process, then the DPR, the House of Representatives, then has to think about putting it first in the legislative priority, because there are 5 phases of lawmaking process. The first is the planning process, and it's written down in the prolegnas, the priority list, and then the drafting process, and then the deliberating process, pembahasan, and then enactment, and then lastly the announcement. Now, instead of going through the 5 phases, of course, it's more practical just to make a shortcut. Yeah, that's what I believe they did, and it should be tested later on by the court in the making of the job creation law. So yeah, that's I think the answer. Thank you, Tanya.
Thank you, Professor. Professor Cammack, would you like to add and perhaps maybe expand a little bit on the APA?
I wish I could expand on the APA, but it's really not my area of expertise. One, to add to what you said, one other factor that sometimes interferes with government executing sound policy is politics. So particularly policies that people are paying attention to and that are going to respond to politically, policy may be guided by what the administration thinks will serve its political interests. In other words, that will help ensure its re-election. Certainly, there was a lot of criticism of the way the Trump administration handled the COVID pandemic, and a lot of that seemed to be politically driven as opposed to decisions were made based on political consideration as opposed to good, sound technical advice. So that's another influence that can interfere with government operating effectively.
Thank you, Professor. Completely agree that sometimes politics can get in the way of policy making, decision making. I think that our last question of the session is another question from Abijuna, joining from YouTube, and this is specifically addressed to Professor Susanti. So Abijuna is asking your opinion on the Indonesian omnibus law and whether it is the function-wise it is already accurate, and does it answer the social and cultural problems in Indonesia. And he's also asking how can he join and contribute in the Indonesian Center for Law and Policy Studies for someone who wants to intern, for example. Thank you.
Okay, thank you, Tania. For the job creation law, my stand is actually clear and consistent that I would say that it's not according to the needs of most Indonesians. And this has been proven actually by the protests, probably only on social media, but there are protests on the number of government regulations implementing the law, such as the regulation on the, how do you call it, the waste from the coal used for electricity. That's one example. And then we also had big debate. It's actually an implementing regulation of job creation bill law again on the investment regulation on alcoholic drinks. And I believe there will be many others, because from the start, because all those government regulations, many of them, there will be even more, are just implementing that job creation law. And there were already issues came up in during the discussion, and we can see how there is big problem from the government, from the implementing regulation. And on the contribution, well, I believe I will just take it to our discussion about the policy making process. Studies from non-governmental organizations such as PSHK and other organizations are always important for the policymakers. And protests are important, but substance on what to actually be put in the reform process is also important thing that we need to work on. So if we conduct, research on practical matters, reform issues, and all that, that will be a big contribution to the policy making process. Thank you.
Thank you very much, Professor Susanti. I think that is our last question of the session. So, and before we wrap up and close this session, I would just perhaps invite Professor Cammack and Professor Susanti to give quick closing remarks. But at least from my end, it's been a very fruitful and insightful session. I've learned a lot from both of you. Thank you very much. And there's a lot of homework for sure to be done, at least on the Indonesian front. But I'm optimistic that we can all work together, including the legal students or other students who are currently tuning in, to participate more in the policy and regulation making in Indonesia. In terms of closing comments, perhaps Professor Cammack, would you like to go first?
Just briefly, I want to congratulate the participants. I was extremely impressed at the interest and sophistication in these technical issues that are really at the crux of how the system works. It's one thing to have an interest in and discuss the controversial matters of what immigration policy should be, but to look at the nuts and bolts of how things get done is really important. And I was very impressed at the degree of interest, of understanding, and commitment to get involved. So, as I said, I'd like to congratulate the participants.
Thank you, Professor. Professor Susanti, would you like to give a short closing remark?
Yeah, I was just nodding very much when Mark was giving his closing remarks, because I agree with Mark that I'm impressed with all the participants, and I hope that will be beneficial for your further study and contribution to the policymaking process. And I would also like to thank Mark, of course, and at America colleagues, that I think this kind of discussion is really useful. Again, not only just by transplanting one idea to another, but to give us horizon. We need to look at, beyond Indonesia, to have imagination on what to do next. And this is what I think the most important thing about this discussion. And I really hope there are many intriguing thoughts for further developments by all participants. Thank you, Tanya.
For sure. Thank you very much, Professor. Again, thank you to both speakers. Thank you for all participants who have been very active. And thank you, of course, to At America for facilitating this very fruitful discussion. I would now return the floor to Maya to close the session. Thank you very much. Have a good day, everyone.
All right, thank you so much, Mbak Kania, Professor Susanti, and also Professor Cammack. That was a very great session. We hope to see you again next time. Now, the rest of you, please don't go anywhere, because I have the name of the winner for our social media quiz today. Earlier in this event, I asked you guys, according to Pew Research Center, in the past 4 decades, the number of democratic countries has been, the right answer is, increasing. And our lucky winner for today is at Momoyama from Instagram. Congratulations! As I mentioned earlier in the beginning of this event, America is having a very special activities with giveaways. And we're giving out not 1, not 2, but 10 tablets for 10 lucky people. And how do you participate? You can participate by posting a picture of your favorite inspirational American woman, tell us how they inspires you on the caption section, and post it on your Instagram or Facebook or Twitter, and simply tag our social media account at ATAmerica. For further information, visit link down below. Now, you may be wondering, how can I develop an awesome idea for a place like this? Easy. You can go to our website at www.atamerica.or.id, click create an event, and collaborate with us. All proposals coming to us will be reviewed, and your event might be featured here soon. And while you're on our website, don't forget to subscribe to our newsletters for weekly event updates sent straight to your inbox. Alright everybody, I think that wraps up this episode. It has been really fun, but unfortunately we have to say goodbye for now. Don't forget to follow us on Instagram, Facebook, Twitter at ATAmerica for event updates, fun content, and so much more. Also, don't forget to subscribe to our YouTube channel as well. Well, thank you so much everybody for tuning in. Have a great day.